Thank you.
Thank you for having me. Yes, I'm Jennifer Wissinger. I'm a physical therapist by training. I've spent most of my career in educational services for students with disabilities across Central and East Central Ohio. I currently work in the early learning program for young children at the Nisonger Center and Community Services. I also teach physical therapy students, physical therapy residents, and licensed OTs and PTs in practice. So thank you for having me today. Today I will just touch briefly on the federal law that outlines education for children with disabilities in school and give a description of some important terms related to special education in federal law. So these are the things that we'll cover today. And first is just the IDEA legislation. It is federal law, so it's implemented at the federal level. This is different from the civil rights legislation that also applies to individuals with disabilities, but the civil rights legislation, like the Americans with Disabilities Act that just recently had its 30th anniversary, is designed to protect from discrimination on the basis of a disability. So it applies to public and private entities where they can't discriminate against an individual with a disability. Where IDEA specifically outlines that children with disabilities have the right to an education. And so this first was passed in 1975. Prior to that, children with disabilities did not go to school. They stayed home or they were sent to institutions, medical or psychiatric institutions for their care. This federal legislation has been reauthorized several times since 1975. Most recently was 2004. And so again, the purpose of this legislation is just to ensure access to education for those children with disabilities. And Part B is primarily what we'll be talking about today. Part B of IDEA applies to children ages 3 through 21. So we know that children with disabilities might need more supports than the typical child in public education. So although preschool services are not required for every child, children with disabilities can access education earlier. So they can start at the preschool age. And then we know that students with disabilities might need more supports to prepare them for life after school. So their education can extend beyond that typical 12th grade graduation. And they can stay in that educational programming through the age of 21 in order to better prepare them for that life after school. So an understanding of how the federal law passed at the federal level then gets implemented at the state level. So states will then have laws and rules about how that federal law gets implemented in each state. In Ohio, these laws are found in the Ohio Revised Code, and the rules are found in the Administrative Code. Then we also have the Ohio Operating Standards, which is the guidance for how we are implementing special education services in our state. You'll hear the term lead education agency. An example of an agency like this is a local school district or the public school district. And a school district may have policies and procedures at the local level that then further outline how that district will implement the state and federal laws. So the local policies and procedures can be more restrictive than the state or the federal level, but they have to at least follow the state and federal laws as well. So how a child gets referred into special education can be through several different paths. If the child is identified in that birth to 3 age range and they're involved in early intervention under Part C of IDEA, they will be referred from the early intervention program into the preschool programming. If a child is older, when they first suspect a disability, it can be identified through the child find process, where districts might have screenings, Head Starts or child care programs might offer screenings or developmental screenings to identify if children are on track or if they are behind in their development, and they might be referred into special education through that process. And then as children get older yet, even all the way up through high school, If a parent might suspect that their child is struggling because of a disability, or the teacher and the school staff suspect that the child might have a disability, they can be referred directly through that process as well. So the purpose of federal law and why we have this law is to ensure that all children with disabilities have the same opportunities to access education as every other child. So a free, appropriate public education. So public education is available to all children, and this ensures that it is also available to children with disabilities. And the end goal is to prepare them for that life after high school, whether that be further education at the college or vocational level, employment in the community, or independent living in order to be contributing members of society. The law outlines special education as specially designed instruction at no cost to the parents to meet the unique needs of the child with a disability. So there's no one set way that special education has to be implemented. It's individualized for each child based on their unique needs. It's specially designed for that student. And again, it's at no cost to the parents. The law goes on to further outline some things that are important for special education to meet. And the first is peer-reviewed research. So the strategies and methods used in special education programming need to be sound and based on peer-reviewed research to the extent practical. Special education can be services provided directly to the child or on behalf of the child. So these might be an example of directly providing a service to the child is the special education teacher providing direct instruction to the child. Services on behalf of the child might be indirect services provided to support the child's programming. Planning for how the curriculum will get modified, or planning the activity, or consulting with other adults that will work with that child. Special education can also consist of program modifications, like having a modified curriculum that aligns with the general education curriculum, but is modified for a specific student's needs. It also includes supports for school personnel. So again, supporting an adult who's already working with that child, or providing supports for the bus drivers that might be needed for a child with a physical disability. And the purpose, again, of that special education is to ensure that that child can make appropriate progress towards their annual goals and be involved in the general education curriculum. So special education isn't automatically a separate curriculum. It is supposed to follow the general education curriculum as much as possible, and then provide any modifications or accommodations as needed. And special education is to also help that student participate in extracurricular and non-academic activities that all the children have an opportunity to participate in. And then finally, children in special education have the right to be educated and participate with children with and without disabilities. So they have a right to not be excluded from where their peers are attending. So the next phrase to understand is FAPE, and you might hear this a lot. It's a free, appropriate public education. We heard that that free part means that there's no cost to the parents. The term appropriate is not as clearly defined in the law. There have been some court cases that have set the precedent about what this means. So in 1982, the precedent was set that appropriate should mean at least some educational benefit. And again, to meet the unique needs of a child, to help them make progress in the curriculum. This does not necessarily mean, though, that that programming needs to be the best possible or the optimal or the Cadillac version to maximize their potential. However, just a few years ago, in 2017, the Andrew case did establish that special education needs to be appropriately ambitious, and every child has the chance to meet challenging objectives. So the bar cannot be set low just in order to show that the child's meeting them and progressing from grade to grade. So the idea of the least restrictive environment applies to that concept of inclusion, and how is that child engaging in an educational program that is at least least restrictive and as close to what their peers without disabilities are experiencing. And so the federal law does say that to the maximum extent appropriate, children with disabilities are to be educated with children who are not disabled, and that separate classes or separate schooling or otherwise removing them from that regular education environment should only occur in those extreme cases when the nature or severity of the disability is such that providing those supports and services does not satisfactorily meet their needs in the general education curriculum. So then the federal law does go on to further describe and define what a disability means. This is a little different from a medical disability or a medical diagnosis. A medical diagnosis alone does not automatically mean that a child has a disability and needs specially designed instruction or special education for educational purposes. Although it is important to point out, one of the categories is autism, and a child can meet the definition of having a disability under the educational category of autism without having a medical diagnosis of autism. Something like an orthopedic impairment is defined as something that causes a physical impairment and limitation. So this is often something like cerebral palsy or spina bifida, something that can cause a physical impairment with the student's performance. Other health impairment is one of those categories that has a broader definition and can apply to a wide range of students. It can apply to students who are very medically fragile and can have be lethargic or have difficulty with their alertness. And it can also apply to students on the other end of that spectrum, students with a heightened alertness to the stimulation around them. So like an ADD or an ADHD type of diagnosis. Multiple disabilities is a disability category that incorporates more than one significant disability and includes an intellectual disability. So in addition to having that intellectual disability, the student might also have a physical disability where programming for just one of those disabilities cannot be does not adequately meet their needs. The category of developmental delay is a more general category and applies only to preschool in Ohio for children ages 3 to 5. So that's used when a child doesn't have another condition identified as being the cause of their disability, but they are scoring low on areas of development, significantly low in one area or moderately low in more than one area. But by the time that child goes on to kindergarten, they must be reevaluated to determine one of the other school age categories that best describes their disability. So once the child is identified by one of those categories to have a disability, in order to be eligible for special education, they must also have a need for specially designed instruction and related services because of that disability. That's not always the case. Sometimes a child might have a disability like spina bifida, for example, that is just a physical condition. It may only affect their ability to move and walk, so they use a wheelchair. They might not have any intellectual involvement. They might not have a need for specially designed instruction. In a case like that, that child has a disability, but they do not need specially designed instruction, so they're not eligible for special education. And then the idea of parental consent or guardian consent is important at all levels. So the parents have the opportunity to give consent at the beginning of the referral process, whether or not to have the child evaluated. If a parent or guardian does not give consent for the evaluation, then the child does not get evaluated for special education eligibility. If the evaluation does take place, but the parents disagree with the findings and they don't agree that the child needs specially designed instruction, then the child would not receive those specially designed services. So the important takeaways, I think, to sum up this federal law is that Part B of IDEA is the part of the federal law that outlines access to education for children ages 3 to 21 who not only have a disability, but because of their disability, they require special education and related services. And then the idea that special education is that specially designed instruction provided at no cost to the parents to meet the unique needs of the individual child with a disability in order to benefit from their education, make progress toward their annual goals, and participate with other children with and without disabilities. These are some links to not only the federal law, but also the state law and rules and the operating standards for Ohio. And then this is my contact information. Thank you so much for your time.
And thank you so much, Jen, for your presentation this morning. We will try to apply some of this information during our presentation as we talk about this young person's special education needs. So you're welcome to sit in and join the learning community. Okay, well, without further ado, we're going to go ahead and jump into our presentation.